Greetings and welcome to Motions, Responding to Parties Procedure and Disposition, condensed from American jurisprudence. Well, before we get started, just to remind everyone that this presentation is strictly for the entertainment educational purposes of this YouTube channel, not to be used, misconstrued, or abused for anything personal, private, lawful, legal, business, tax, financial, or otherwise, so please don't do this at home. That said, if you just entered in, please hit the like so we can get the notifications out there. Didn't get one this time, but hopefully it went out for you all. And let's get started. So, where we left off last time was just in the motions, and now we're getting into the end of the affidavits is the opposing affidavits from where we left off last time. So we're going to start with generally the answer to opposing affidavits. This is the responding party's procedure. Response requirements to motions vary by the jurisdiction, but the core principle is that responses should counter factual claims with affidavits. And courts retain broad discretion to manage the process, including considering late filed opposition. All right, so again, the affidavits are considered factual and can be considered evidence if they're not opposed. And they must be opposed properly according to the responding procedure for the parties here that are opposing the affidavits. So, a written answer to a motion is not always required unless a statute or court rule mandates it. A reply affidavit's function is to rebut arguments, not to raise new issues or change the motion's nature. Some jurisdictions allow courts to consider new arguments in a reply for judicial economy, provided there is no prejudice. So, new arguments may be considered in a reply for judicial economy. So, that's going to be wrapped up in that judicial economy for a new argument to be considered, provided there's no prejudice, and only facts affirmed by affidavit need to be countered by a counter affidavit. So, two important points here. As long as bringing in the new arguments in a reply just for judicial economy and there's no harm to the other party, then some jurisdictions may allow courts to consider that. But only facts affirmed by affidavit need to be countered by a counter affidavit. There's other ways, but what they're also saying here is that facts not rebutted on the affidavit will stand and be admissible as evidence in many cases unless countered. And the way they're supposed to be countered according to the responding party's procedure is by counter affidavit. Trial courts are vested with discretion to consider opposing affidavits to motions which are not served within statutory time limits. So even if they're not within a particular time limit according to statute, the opposing affidavits, trial courts are vested with discretion. So they have an inherent power to have discretion over whether to consider an opposing affidavit, even if it's not served within a statutory time limit. So they're not bound by those statutes and that discretion. All right, we're on to the time for response. While rules set specific response times to ensure efficiency, courts generally have discretion to extend these deadlines, particularly when a party shows, here's one of the ones we saw from the last one, excusable neglect, but not simply for being too busy. So statutes and rules set response time periods to facilitate the court's efficient disposition of motions. These procedural rules are mandatory to ensure a just, speedy, and inexpensive determination of an action. Trial courts have discretion to consider late filed opposing affidavits. So there sums up our times for response. Remember, excusable neglect. So excusable neglect, not simply for being too busy. All right. Of course, that's to the court's discretion. Section 27, time for response. Judges can often extend or limit filing periods. But this is not an unfettered authority. Excusable neglect may be required. A general claim of being too busy is not a sufficient reason to compel a court to grant an extension. And courts generally cannot shorten the response time unless a rule or court order specifically allows it. So they generally, here's our presumption here, generally cannot shorten the response time unless there's a rule or court order. So, of course, the court order, it could be coming from that court. So back to our practice tips here, one of the nice gems of American jurisprudence. Where an objection or exception is made to a motion, a party owes the trial court the obligation that such objection or exception be sound, clear, and articulate, so as to permit the trial judge a chance to consider the legal contention. So when the party owes the trial court the obligation that such objection or exception be sound. So this is another, normal kind of part of the procedure here, that the party owes the trial court the obligation that the objection or exception be sound, clear, and articulate, so as to permit the trial judge a chance to consider the legal contention. So again, the trial judge here is the subject that needs a chance to consider the legal contention. And the observation here is the failure to allow a party to respond within the allotted time to file responses or objections to motions involving contested issues of law is an abuse of discretion. So the failure to allow a party to respond within the allotted time to file responses or objections to motions involving contested issues of law is an abuse of discretion. So key here, when the failure to allow a party to respond could be an abuse of discretion. Let's move along here. Not sure if the notifications went out. If so, please give me a confirmation in the chat so we know that everything is moving smooth, and we'll continue on here. On to section 28. Effect of failure to respond to motion. Failing to respond to a motion is risky, as a court may interpret it as non-opposition or even an admission of facts. But the moving party still bears the burden of proving their case, and the court must still review the motion's merits. So failure to respond can be construed as non-opposition, an admission the motion is meritorious, or that the facts alleged are true. Courts must exercise great caution before imposing such severe consequences, and must still review the motion's justification. So it must be clear in its justification in law, regardless of a failure to respond. An uncontested motion is not granted as a matter of right. The court retains discretion to review it. All right, let's move along here. All right, and if can't inspire anyone enough to try it out, if you go into the chat and you send something, listen to what it'll do now.
The tribe says, hit the like.
Yeah, so it does a little thing like that now. So let's add a little spice to it. Let's proceed. So, the effect of failure to respond to motion. Some jurisdictions failing to respond within a specified time waives the right to present evidence in opposition. Waives the right if it's not done within a specified time. So you must respond within a specified time, or in some jurisdictions it may be waiving.
Auditor says audio clear.
Nice. Okay. Excellent. All right. And we're on to, even with a waiver rule, the court may still have discretion over the response period. And our practice tip. Although failing to file a written response to a motion a litigant opposes, even to point out the obvious, is certainly ill-advised. And a non-moving party who fails to respond to a motion or make an appearance at the motion hearing assumes a substantial risk that the trial court will act favorably on the motion. The moving party still has the burden of demonstrating to the trial court's satisfaction that he is entitled to the relief requested. Wow. So here's our extensive practice tip. So, of course, it's ill-advised to not file a written response. A non-moving party that fails to even make an appearance at the motion hearing assumes a substantial risk. The moving party, though, still has the burden of demonstrating to the trial court satisfaction that he is entitled to the relief requested. So just because the other party doesn't show up, or fails to respond, doesn't mean that the moving party is relieved of that burden of demonstrating to the trial court satisfaction that he is entitled to the relief requested. And another practice tip is a rule requiring a party opposing a written motion to file a memorandum in opposition, and allowing the court to dispose of such motion without argument if such memorandum is not timely filed, may not preclude the opposing party from raising oral objections at the hearing on the motion. Wow. So even if the paperwork is not accepted, it may not preclude the party. So it's not a shall, it's a may not. Nonetheless, there's a rule in some jurisdictions. So we don't know which one that is, and that's your homework. If you think this might apply, check in your jurisdiction. And we're on to the cross motions, section 29. Cross motions are generally an improper vehicle for seeking affirmative relief and are often considered superfluous, unless they directly incorporate matters raised in opposition to the main motion. So we get the do not enter. A cross motion is generally improper for seeking affirmative relief from a non-moving party. Motions like a demurrer to a motion or a motion to dismiss, deny, strike a motion are characterized as superfluous and bad practice. A court's refusal to consider a cross motion may be error, though, if it attempts to incorporate a matter presented in the opposing papers to the main motion. So, the practice tip. The record of a cross motion.
2001 says, Oakland love.
Indeed. Thank you. Less TV. All right, so a court's refusal to consider a cross motion may be error if it attempts to incorporate a matter presented in the opposing papers to the main motion. Wow. So if they're grabbing stuff from it, then indeed, the record of a cross motion includes the record of supporting the original motion. So that's your practice tip there. You can see where it may apply cross motion. Seems like an exception more than standard practice. Now we're on to section 30, and we're on to part 2 with disposition. Now that we've gone over the responding parties procedure, courts have wide discretion in granting or denying motions, but this discretion is not unlimited. Rulings must be based on the motion's scope, applicable legal standards, and principles of substantial justice. Determining a motion is a question of law, and the courts have wide discretion. Discretion must be exercised in a manner consistent with substantial justice and court rules. A court may not grant relief beyond the scope of the motion's notice. So remember we spoke about the motion's notice. Court may not grant relief beyond the scope of the motion's notice, unless rules allow for sua sponte decisions or partial alternative relief. Wow. An unopposed motion is not automatically granted. The court must be satisfied that legal standards are met, as we saw before. It doesn't relieve the moving party from the burden, proving they have a substantial case. And a ruling on one motion is an implicit denial of another contradictory pending motion. So this is a key concept here. A ruling on one motion is an implicit denial of another contradictory pending motion. And let's continue with section 30 generally. It's another practice tip. Some jurisdictions have procedural rules requiring that where a motion involves separate grounds or parts, the court must rule separately on each and may not determine the motion generally. Wow. So Some jurisdictions involving separate grounds or parts, each must rule separately. Where such rule applies, failure to comply with the rule may be reversible error. Okay, so go back and do that then. All right, so observation. When a court strikes a motion, it is striking the hearing on the motion rather than the ruling on the motion. And such, the motion is revived by resetting the hearing. So striking a motion is not a good practice, it seems. That's an observation. So let's get to our practice tip. The party making a motion must follow up that action by bringing it to the attention of the judge and by requesting a hearing upon it. Additionally, in this regard, it has been said that it is the responsibility of the party filing a motion to obtain a ruling from the court on motions filed by him or to request the trial judge to rule on it, and that a trial court is not required to consider a motion unless it is called to its attention. Wow. Even so, once a request for a hearing on a motion by one of the parties has been granted and the matter set for hearing, the other party may have a right to rely upon such setting regardless of whether it made its own request. Wow. All right, so some serious practice tips here. One thing I think you could leave with this is that a party making a motion must follow up that action by bringing it to the attention of the judge and by requesting the hearing. So you request the hearing and you have to bring it to the attention of the judge. So it's a responsibility of the party filing the motion to obtain a ruling from the court on the motions filed by him or to request the trial judge to rule on it. And the best part here, the trial court is not required to consider a motion unless it is called to its attention. So if you don't speak up, they are not required to consider it. And even so, once a request for hearing or motion by one of the parties has been granted and the matter set for hearing, the other party may have a right to rely upon such setting regardless of whether it made its own request. So there it is. Requesting it is important. Somebody's requesting it. If somebody requests it, the other party has a right to rely on such a setting, regardless if it made its own request. So again, sometimes being silent on these things is not a good thing. Section 31, pending motions, abandonment, waiver, or withdrawal. A motion not yet ruled on is pending, but it can be deemed abandoned or waived if the movant fails to pursue it. A motion can be withdrawn, which effectively erases it from the record. Wow. So it can be withdrawn is like erasing it. A motion filed but not ruled upon, dismissed or withdrawn, is pending. Failure of the movant to proceed with a motion may result in it being considered abandoned. The decision to deem a motion abandoned is within the court's sound discretion. So the court can determine whether it's been abandoned. All right, now we're on to pending motions, abandonment, waiver, or withdrawal, part 2. A party making a motion can generally withdraw it before the court rules, provided no prejudice has occurred. So as long as you're not harming the other party by withdrawing it before the court rules, then a party can generally withdraw. A motion withdrawn in the court's present is no longer pending, even without a formal order. Because that's, I think you're right. Practice tip. The effect of withdrawal of a motion is to leave the record as it stood prior to the filing. That is, as though the motion had never been made. An observation here is the setting and hearing of or continuing of pending motions are matters committed to the trial court's discretion. A lot of discretion here with these motions like this. If they've been abandoned, there's waivers, withdrawals, anything like that. The courts have that judicial economy to consider, so that's where this pipes in. Observation. A subsequently filed notice of appeal following the failure by a litigant to obtain a ruling on a motion serves as an abandonment of the previously filed motion. So a subsequently filed notice of appeal following the failure to obtain a ruling on a motion serves as an abandonment. Wow. So you need the ruling. And of course, if it's until the ruling's done, if it's done after an appeal, then it's not part of that appeal. Interesting. Okay. We're on to section 32, hearing on motion, generally and necessity. While the opportunity is to be heard is a fundamental right, courts have broad discretion to decide motions without a hearing, especially for non-dispositive motions or when the motion lacks substance. So a hearing is a non-jury proceeding where evidence is taken or an opportunity to be heard. Parties' right to respond to a dispositive motion is deeply embedded in fair play and justice and, of course, due process. The decision to hold a hearing is generally within the court's discretion. All right. A hearing may not be necessary if the paper submitted raised no factual dispute on a material point being central to the controversy. The non-dispositive motions. For non-dispositive motions, a hearing is not required, and the court has great latitude in deciding whether to hold one. In our observation here, the requirement under civil procedure rule governing motion hearings that a hearing be held before the court makes a ruling which is dispositive of a claim or defense refers to those claims or defenses which are intrinsic to the underlying cause of action, and not to those which are dispositive of collateral matters. So that's a big one there. When the hearing makes a ruling which is dispositive of a claim or defense, it refers to those claims which are intrinsic to the underlying cause of action, not to those which are dispositive of collateral matters. So again, the material point. Unless a hearing on a motion is specifically required by court rule, failure to conduct a hearing on that motion ordinarily will not constitute reversible error absent abuse of discretion. There is no abuse of discretion when the complaining party can point to no single definable aspect of its position which could not have been adequately presented by a written submission. Oh boy. Of course, you got to bring that written submission to the attention of the judge. By noticing a hearing. Types of hearing required. The type of hearing, oral, evidentiary, or non-oral, depends on the nature of the motion and the jurisdictional rules. An evidentiary hearing is reserved for cases where specific material facts are in dispute. So there's central to the case, not just in circumstances. Oral hearing, no evidence, only arguments of counsel. Evidentiary hearing, evidence is taken. Non-oral hearing, determined on written submissions alone. A party's timely request for a hearing on a dispositive motion generally requires the court to provide an oral hearing, generally, unless rules state otherwise. So check your jurisdiction, as always. And type of hearing required. Whether to hold an evidentiary hearing is a discretionary decision of the trial court. An evidentiary hearing is only required if the moving papers allege facts with sufficient specificity that relief would be granted if proven. That's the only time it's required. The moving papers allege facts with sufficient specificity that relief would be granted if proven. Key point there with the exclamation point for sure. And no evidentiary hearing is required for motions involving only questions of law. And here's our practice tip. A party who requests an evidentiary hearing may be required to set forth the reasons why such a hearing will further assist the court in determining whether to grant a particular motion. So it seems like that would be a good practice in general to anticipate this, because that would be the major pitfall, is to not be able to articulate clearly the reasons why such a hearing will further assist the court in determining whether to grant a particular motion. And we're on to the time and place for hearing. Courts have broad discretion over their dockets and scheduling, but must rule on motions within a reasonable time and provide adequate notice, as shortening time limits to the point of preventing preparation is a due process violation. Courts must consider and rule on a motion within a reasonable time. The trial court has discretion to control its proceedings, including setting hearing times. A court may shorten time for a hearing if there is good cause, ample notice, and time to prepare. And the time and place for hearing. Reducing time limits to the extent that a party cannot prepare is a denial of due process. A court has great discretion over its docket but cannot forever avoid a hearing motion. Motions should generally be heard in the order they were filed or noticed. And a practice tip: the fact that a cause is continued from time to time does not necessarily render a motion invalid for failure to set a hearing within a specified time. So that a cause is continued does not render the motion invalid for failure to set a hearing within a specified time. So the continuance would cause that time limit to not apply. Practice tip: the view has been followed in some jurisdictions that where either party has filed a timely request for hearing on a motion that may be dispositive of a claim or defense, the court generally must provide an oral hearing and adequate notice of the time, place, and nature of that hearing before entering an order that is dispositive of the claim or defense. However, in some jurisdictions, if a party does not attempt to secure a time for oral argument on a motion, the request for oral argument is deemed incomplete. So, secure a time for oral argument on a motion, or attempt to secure a time, the request is deemed incomplete. And we're on to Section 35, the conduct of a hearing. The judge controls the conduct of the hearing, including whether to allow oral argument. The moving party bears the burden of proof, and for dispositive motions, facts are viewed in the light most favorable to the non-moving party. The conduct of hearings is largely within the judge's discretion. Courts may decide whether briefs are required or if the matter can be decided on the record alone. Wow. And parties may not be entitled to oral arguments on motions. The court may deny it. So the judge controls the conduct of the hearing, including whether to allow oral argument. And continuing with the conduct of the hearing, the burden of proof is on the movant to demonstrate entitlement to relief. A hearing need not address every aspect of a motion. As we know, parts can be decided without a hearing. Parties' rights are determined at the time the motion is argued, not when it was filed. So parties' rights are determined at the time the motion is argued, not when it was filed. In a hearing on a dispositive motion, facts are viewed in light most favorable to the non-moving party. And continuing with the conduct of hearing, here's some of our practice tips. It has been stated that while a request for oral argument respecting a substantive motion may be denied, the reason for the denial of request in that circumstance should itself be set forth on the record. Should is not good enough. It shall, I would say, but it should is what the words are here. So it should be itself be set forth on the record, the reason for the denial of the request. Another practice tip here is parties' rights are to be determined at the time when the motion is argued and submitted to the court for determination, and not as of the date the motion was filed. And our observation: in some jurisdictions, it has been held that a blanket rule by the trial court not to do telephone appearances would be a violation of the applicable rule permitting a requesting party to participate through communication equipment in a scheduled motion hearing. Telephone. So this is going back to 2012, this edition of American Jurisprudence that Condensed is from, which takes us to section 36, reception of evidence. Evidence on motions is typically limited to, here we go, affidavits, declarations, and the existing record. Courts generally refuse to consider new evidence offered for the first time with a post-trial motion if it could have been presented earlier. For this a lot too, if it could have been presented earlier. So it's always good if you're bringing in new evidence to explain why it wasn't presented earlier to prevent that from coming in to bite back. Courts may consider affidavits, oral testimony, or depositions when ruling on a motion. Factual issues are typically submitted on affidavits or declarations. A court may refuse to permit irrelevant affidavits or exclude irrelevant evidence. Now on to reception of evidence. The contents of exhibits to pleadings are part of the record and can be considered as evidence. A court can only consider material before it at the time of submission. Material filed later comes too late. And observation here, a trial court can consider only material before it at the time of submission of a motion, and material filed thereafter comes too late. A movement's proffer of additional service after his motion is denied and may waive his earlier motion, and when he later moves again, the new motion may be determined upon all evidence regardless of by whom it is offered. So, another practice tip: if evidence offered for the first time in a post-trial motion could have been produced at an earlier time, the trial court may deny its introduction into evidence. May. And there's a time for ruling on motion, section 37. And, I guess we didn't get the, I guess we could set a little bell when these things come up. Yes, it's supposed to speak, but I guess it doesn't speak icons. If you throw something else in there, it should speak. At least I'm hearing it. I hope you guys are too. If you want to throw one and test it, you'll see what I'm saying. So a court must consider and rule upon a motion within a reasonable time. Some jurisdictions specify a period for ruling, which may be extended or shortened by the court or by agreement. A court has discretion to rule on motions in whatever order it believes most logical and efficient. This exercise of discretion is only reviewable for an abuse of discretion. So it's not right or wrong, it's whether it was an abuse. Practice tip: the procedure for enforcing provisions of rules establishing time periods in which trial court must rule on motions and matters taken under advisement where a clerk erroneously refuses to recognize that a cause should be withdrawn is to file an original action. The party may not wait until an unfavorable judgment or ruling has been made and then seek to invoke or enforce such rules. Wow. Interesting. And we're on to the failure or refusal of court to rule on motion. Courts generally cannot refuse to consider a properly filed motion, and a failure to rule may be treated as a denial or overruling by operation of law in some jurisdictions. Yeah, okay. So a trial court with jurisdiction lacks authority to refuse to consider a litigant's motions, except in extreme circumstances. Court's desire to clear its docket is not a valid basis for refusing to consider a motion. Failure to rule is not always the equivalent of a denial, but some jurisdictions hold the contrary view. Wow, failure to rule is not always the equivalent of a denial, but some jurisdictions, check your jurisdiction. A motion not decided when a case concludes is sometimes presumed to have been overruled. Sometimes presumed. Wow. A lot of qualifiers there. A motion may be deemed denied by operation of law if the judge does not rule within a prescribed time. And this is a fact here I've seen. Indeed. Section 39, form of ruling. Inclusion of findings and conclusions. Now, this is very important. That's why you see it's a very dense slide. And if you guys in here have just joined in, please hit the like. And if you type something into the chat, I think it's going to do the text to speech for us. Let's see if that works. Anyone wants to try it out, feel free. So while not always granted, it is preferable for a court to provide the reasoning for its ruling, especially for dispositive motions, to give parties the benefit of the court's analysis. After ruling on a motion. Now, pay attention here because while it's not always required, that means sometimes it is. After ruling on a motion, a court generally need not issue a statement of decision or findings of fact and conclusions of law. Court generally need not. The court has discretion to make such findings and conclusions. The preferable practice, particularly for dispositive motions, is for the court to explain its reasoning. That's the preferable practice. So here's our observation. Some jurisdictions, tentative rulings indicate the way the judge is prepared to decide the matter based on the information before him or her when the ruling was prepared. Such a tentative ruling becomes the final ruling of the trial court. One, only if the court does not order oral argument in its tentative ruling and notice of intent to appear is not given by one of the parties. Oh, wow. Or two, only after the hearing on the motion is conducted, assuming the court does not then render a different ruling. So we have these tentative rulings. And it's indicating a way a judge is prepared to decide on the matter, given the information before him or her when the ruling was prepared. And it becomes a final ruling if the court does not order oral argument in its tentative ruling. Wow. And the notice of intent to appear is not given. So one of the parties has an intent to not appear, or only after the hearing on the motion is conducted, assuming the court does not then render a different ruling. So only after the hearing is conducted and the court does not render a different ruling. So it's kind of just run through the ropes. So there it is, the form of rulings. It's not always required, but it's preferable for the judge to issue facts, findings of fact, and conclusions of law in ruling on a motion. However, sometimes, and see if we're going to get into there, here we might be able to touch into it a bit here. Section 40 on generally the reconsideration, rehearing, and re-argument. This is from Part 3, the procedure after abandonment or denial. A motion for reconsideration is a narrow remedy used to correct clear errors, present new evidence, remember the problems with that one, or prevent manifest injustice. It's not a second chance to re-argue the same points. A motion for reconsideration is an invitation for the court to vacate or modify its own judgment, an invitation. It is limited in scope and is the functional equivalent of a motion to alter or amend judgment. So it's a functional equivalent of a motion to alter or a motion to amend. This is our motion for reconsideration. A court may reconsider based on a matter presented in a new light, a change in law, new evidence, manifest injustice, or to correct its own errors. The decision to grant reconsideration is within the sound discretion of the court. And a motion for re-argument is used to seek review of findings of fact, conclusions of law, or judgment. So that's the motion for re-argument is used to seek review of findings of fact, conclusions of law, or judgment.
Sawyer Stash says it is a beautiful autumn week to come, which some say is an Indian summer, whereas a mighty good time to baste the beaver with the baby batter. This is a test. Much love to the tribe.
All right, thank you. Did everyone hear that one? I did, and indeed, it is a beautiful autumn. All right, so we have here that the motion for re-argument, this is key here, and we'll do a little more research on this one here, is used to seek review of findings of fact, conclusions of law, or the judgment. So we have three forms: reconsideration, rehearing, and re-argument. And we're on section 40, generally, reconsideration, rehearing, and re-argument. A motion for re-argument is not intended to rehash arguments already decided. So the name seems like a misnomer, but it's really about bringing those facts and conclusions of law into light. It cannot be used to present new arguments not previously raised. Generally, new evidence cannot be submitted with a motion to reconsider a final judgment, but this rule may differ for interlocutory orders. Rule must be narrowly construed to avoid repetitive arguments. So you don't want repetitive arguments, it's a re-argument. And it's not intended to rehash arguments already decided. However, it is to seek seek review of findings of fact, conclusions of law, or judgment. Oops, one more time. There we go. And we're on to, again, with more of the reconsideration, rehearing, and re-argument with the practice tip. The right to present new facts in support of a motion for reconsideration of an interlocutory order is not lost by joining the motion for reconsideration with a motion to amend the findings of fact or conclusions of law. Wow, despite the rule that a trial court cannot consider new evidence when asked to reconsider a final judgment pursuant to a motion to amend the findings of fact or conclusions of law. Yet when the evidence is not newly discovered, a party may not submit that evidence in support of motion for reconsideration. So this is all for the motion for reconsideration of an interlocutory order. It's not lost by joining the motion for reconsideration with a motion to amend the findings of fact or conclusions of law. So you're asking to reconsider and to amend it, and that would be joined. Despite the rule that they can't consider new evidence, you want them to add some findings of fact or conclusions of law. When the evidence is newly discovered, a party may not submit that evidence in support of this motion. They may support it other ways, but not within this motion, it seems. And our observation, while manifest injustice may be a reason for granting relief on a motion for reconsideration, resulting prejudice to the other party may also be a reason for denying reconsideration of an order as well. Wow. And a practice tip, although the matter is within the discretion of the trial court, generally, where one party files a motion for re-argument and the opposing party files an answer, the opposing party may not file its own motion for re-argument. So it's first come, first serve here, it seems. Motion for re-argument, that's an interesting one there. Case 1 here. A motion for reconsideration should be granted only if the court finds there is intervening change of controlling law. Intervening change, availability of new evidence, which is difficult, or need to correct clear error or prevent manifest injustice. That comes from the Federal Rules of Civil Procedure and Harris versus District of Columbia and DC 2010. And as we saw here, manifest justice. Manifest justice and prejudice to the other party. Balancing act there. All right, we're on to case 2. Motions for reconsideration in civil actions are appropriate only in a limited number of circumstances. Ooh. If moving party presents newly discovered evidence, if there has been intervening change in law, or if movant can demonstrate that original decision was based on manifest error of law or was clearly unjust, and of course, not prejudicing the other party. A motion for reconsideration must clearly establish either a manifest error of law or fact, or must present newly discovered evidence. Such motions cannot be used to raise arguments which could and should have been made before the judgment was issued. So don't save them for afterwards. Take care of them all at the hearings. And that comes from Brown versus DFS Services, LLC, and that's in Texas 2010. Oh, hang on a second. Sheesh. This is a really cool feature for chat comments, opportunity to dial in the AI voice to less robotic voice. Yeah, that'd be interesting. Yeah, Sawyer Stash has some reason it got, I don't know why, but it got censored. Nonetheless, didn't show up on this panel, but I did see it on the YouTube app. Try typing again. I think maybe it was the sheesh or something like that. Maybe it didn't like. Or, oh, sexy maybe? I don't know. Well, there's some word in there that the censors didn't approve of. Nevertheless, we're on to renewal. Section 41. Renewing a motion is distinct from reconsideration. It requires a showing of new facts that could not have been offered earlier, a change in the law, and a reasonable justification for the initial omission. So, new facts really need a reasonable justification. The trial court may have jurisdiction to entertain a renewal of a previous motion, which may require leave of court. So, renewal of a previous motion, which may require a leave of court. So, remember, a leave of court is just to do something outside the normal procedure and get permission to do it. It doesn't mean to actually leave. A motion for leave to renew is addressed to the sound discretion of the court and is granted sparingly. A motion for leave to renew must be based on new facts not offered previously and set forth a reasonable justification for the failure to present them earlier. Better have a good excuse. And finally, on to renewal, with courts have the discretion to relax the new facts requirement in the interest of justice. Renewal may also be granted if there has been a change in controlling law. So the courts have discretion to relax the new facts requirement. The practice to appear a motion for renewal generally must be made to the same court and judge who signed the original order. Observation: a trial court lacks discretion to grant renewal where the moving party omits a reasonable justification for failing to present the new facts on the original motion. So if there's no justification, there's no discretion. And observation here, denial of a motion without prejudice impliedly invites the moving party to renew the motion at a later date. So without prejudice, it implies that the moving party can renew that motion at a later date when he can correct the deficiency that led to the denial. Indeed, and seen this one too, that is quite correct. Takes to our conclusion. Legal motion procedures require understanding, court discretion. We just went over in detail. Proper timing. Remember, there is discretion on that too. However, nothing beats having it on time because there's somewhere it would be prejudicing the other party if there was outside the normal procedure. And strategic response, the way the responding party must address certain facts, affidavits, allegations, etc. This presentation has covered the essential procedures and dispositions related to motions in legal proceedings, focusing on the responding party's rights and obligations. So courts have broad discretion in managing motions, but this discretion is not unlimited and must align with the principles of substantial justice. Response timing is critical, with courts balancing efficiency with fairness, allowing extensions for excusable neglect, but not for being too busy. Hearings are not always required, especially for non-dispositive motions, with courts having great latitude in deciding whether to hold them. And reconsideration is a narrow remedy for correcting clear errors or preventing manifest injustice. It's not a second chance to re-argue the same points. So we've learned here that in motion practice, timing, strategy, and proper documentation are paramount. A well-argued response can save time, preserve rights, and prevent irreversible consequences. So, as they always say, a stitch in time saves nine, and there should always be time to do things right the first time, not time to do it over and over and over again. So, with that said, that takes us to the end of the presentation here. I'd like to thank you all for joining me here on discovering more about motions and the responding party's procedure and the disposition of the motions here and how they're handled by the judge. We'll continue on. We have a couple more sections on this. Next time, I think it'll be going over rules or orders. And this will really sum up a fundamental section from American jurisprudence. So salute to you all for being here, and I hope to see you all on the next one. Peace out.